I'm Sabrina with the 2-Minute CRA News you need to know. Let's talk about one of the hottest topics in the state capitol, electronic privacy. Specifically, the California Consumer Privacy Act. The CCPA was quickly passed in 2018. That speed led to a lot of questions and a lot of problems. The law applies to any business that collects 137 unique credit cards or receives 137 unique website visitors daily. That affects large, medium, and small restaurants. Over the next few weeks and months, you'll hear from the CRA about bills aimed to fix the CCPA. Some good, some bad for the restaurant industry. Well, here's a good one that CRA advocates are working on, Assembly Bill 25. First, a little background. The intent behind the CCPA is to provide a consumer with additional electronic privacy protections. And under the CCPA, the definition of a consumer is any California resident. Yes, any. And that becomes an issue with the CCPA's Right to Delete section. Under the Right to Delete section, a consumer has the right to request that a business delete any personal information about the consumer which the business collected. Note, a business does not need to comply with the consumer's request if they need the information to fulfill a transaction. The concern is that, under the current law, the broad definition of consumer could lead to employees requesting that their employers delete their personal employment information. For example, if someone was fired for sexual harassment, could an employee ask their employer to delete any personnel records they might have? And that's where AB 25 comes in. AB 25 clarifies the definition of consumer, so an employee, job applicant, or contractor would not be captured in the definition, creating a clear distinction between an employee and a consumer. We get that protecting consumer privacy is important. The CRA is working to ensure that laws designed to do so are reasonable and feasible for restaurants to follow. That's our 2 minutes. I'm Sabrina. Thank you for watching.